Hello everyone, I am Dr. Mahalakshmi, educator, forensic medicine and toxicology. This video, it is an introductory part of forensic medicine. So, forensic medicine basically deals with the legal procedures that is involved in the medicine field. So, we will be seeing about all these basic things, the basic understanding about forensic medicine and introduction into the forensic medicine here. And this forms an important aspect of forensic medicine, not just for your exam purpose, in your real life, practical purposes, when you become a big practitioner, when you are practicing in your own clinic or working in some setup, this will be highly useful for you because this is purely a practical thing. These are the things everyone must know regardless of their specialty. So first of all, we will be seeing certain definitions because these definitions, they are very important for your exam point of view. They will simply ask you what is forensic medicine, what is medical jurisprudence, what is medical ethic and what is medical etiquette. Like that they will ask you a lot of definition. It can be asked in Viva or it can be asked as a 2-mark question also. So with that in mind, we will start on this chapter. So first we are starting with forensic medicine. So what is a forensic medicine? What is a definition of forensic medicine? So it nothing but it is application of medical knowledge. So you will apply your medical knowledge for administration of law and justice. So for the administration of law and justice, you will be applying your medical knowledge. This is a raw vague definition of forensic medicine. You will use your medical knowledge and it will be used for the administration, like application of the law. If there is any murder, if there is any theft or something where your expertise is needed, then you will be applying your medical expertise and you will assist the system of law and justice to administer the actual fair treatment to that victim and the assailant. So this is the forensic medicine main purposes. It is application of your medical knowledge in administration of justice. This is the forensic medicine definition. Now we are done with this. Next definition they will ask you is what is medical jurisprudence? So jurisprudence means it is law. So medical jurisprudence means it is the legal principle that guides your medical practice. So if you are a doctor, if you are a medical personnel, you have to adhere to certain laws. So all those legal principles, all those laws, we call it as medical jurisprudence. The laws and legal procedures that is constrained to the practice of medicine, that is constrained to a medical personnel, we call it as medical jurisprudence. So this is medical jurisprudence and this is forensic medicine. Now we have something known as medical ethic. You have medical ethic and medical etiquette. So what these two is that ethic deals with doctor-patient relationship. The legal principles that guides doctor-patient relationship is your medical ethic, and etiquette means it is doctor relationship. The principle, that values that guides the dealing between a doctor and another doctor consists of the medical etiquette. Ethics between doctor and patient, etiquette between two doctors. So these are the important basic definition that we have to know. Whenever someone asks about forensic medicine, definition is must. Without knowing the definition, there is nothing much we can say about forensic medicine. So forensic medicine definition, application of medical knowledge in administration of justice. Medical jurisprudence, it is the legal principle that guides the medical personnel in his practice. And medical ethic, it the legal principle that guides the relationship between doctor and patient. Etiquette, it is between two doctors. So these are the basic definition one must know while entering forensic medicine. And with this in mind, we are going to see about certain legal procedures, because we will be dealing with lot of criminal cases and few civil cases in our period. So now the offences, all the offences, it will be covered in this legal procedures. So legal procedures, we will be seeing offences, and apart from that we will also be seeing about the court procedures in this. So first, offences, you have mainly two types, that is civil and criminal offence. You have the civil offence and criminal offence. The main difference is that in civil offence, it mostly be a person versus person dispute. It is something mostly like monetary related, something very less damage caused. Those kind of things will be covered under this civil offences. Criminal offences, they are mostly serious offences, and this is usually fought as state versus the person, that is the accused person. So the case, it will be taken up by the state, and the state will be fighting against that accused person. So this is the seriousness between the civil offence and criminal offence. So when we say criminal offence, your murder, all these things, rape, murder, everything will be coming under this criminal offences. Civil offences, like any negligence suit, like someone is saying that because of the negligence they suffered some damage, those kind of thing will be coming under this civil suit, like defamation cases, all those simple cases, it will be coming under this civil offences. So this is the basic thing, civil offence and criminal offence. And apart from that, you also get something known as cognizable and non-cognizable offence. So these two, they are very, very important. They will frequently ask you what is a cognizable offence and what is a non-cognizable offence. So just remember one thing, in both the cases, you will not have warrant. So without warrant. This is the scenario which we will be seeing. Both cases, there will not be warrant. If it is a cognizable offence, police can arrest. If it is a non-cognizable offence, the police cannot arrest. See, C, C and N, N. So, if it is a cognizable arrest, the police can arrest without warrant. If it is a non-cognizable offence, the police cannot arrest without the warrant. Usually, this cognizable offence is something very, very grave, like rape, murder, ragging. All these serious offences, all these grave offences, it comes under this cognizable offence. So what happens is that if such cases are reported, the police will go and directly get the criminal. They will arrest the accused person and they will produce him in front of the magistrate within 24 hours of detention. Afterwards only they will get the arrest warrant, and if the judge give the arrest warrant, the magistrate, if he said that person can be arrested, if he issues the warrant, then the person can be like hold on. Okay, he will be detained for few more hours and the investigation will go on. This is how things happen in cognizable offence. If it is a non-cognizable offence, if a case is reported to the police, what the police have to do is, they have to get permission from the magistrate. From the magistrate, they have to get the permission, and afterwards the magistrate issues an arrest warrant. Then only they can go and arrest that accused person for detention. So this is how thing usually works. Normally, if a case is reported, the police, they will file the FIR and they will go present it to the magistrate. So the magistrate, after listening to the police case, he will say whether that person can be arrested or not. If he says yes, then the warrant would be issued. Once the warrant is issued, the police will go and arrest the accused person and they will detain that person and they will do further investigation. And this is how the normal procedure happens. If it is a serious issue, if the police says it is like very big issue that we cannot wait for warrant, we have to get that person, then in such cases, they will go arrest without any arrest warrant. But once they arrest the person, within 24 hours, they have to produce that accused in front of the magistrate for getting the warrant for further detention. They cannot hold him beyond 24 hours if the warrant is not issued by the magistrate. So, this is the difference between the cognizable offence and non-cognizable offence. Cognizable offence, just remember, it is usually a serious offence and the police does not need any sort of warrant for arresting that accused. If it is a non-cognizable error, it is relatively less serious and the police, they cannot arrest without warrant. So, in both cases, you remember it is without warrant, and if there is cognizable, only C is present, they can arrest. If it is non-cognizable, there is both C and E, then the police cannot arrest. So, this is the main type of offence that we have to know. First is your criminal and civil offence. Even in that civil and criminal, we have this cognizable and non-cognizable offence. So, these are the important types in case of offence. Next step is inquest. So, if something happens, if some offence happens, next thing would be the investigation. So, what the police will do is they will investigate, and inquest means investigation into the cause of death. So, this is the meaning of an inquest. The actual meaning of inquest is just this. The police, they will investigate into the cause of death. And this inquest, it has lot of types. The most important types that we will be seeing is police inquest, and you have executive magistrate and judicial magistrate. So, this is the main type that we will be seeing now, because these are the commonly used and the only used system in our country. In our country, we either do police inquest or magistrate inquest. Apart from these two, there are few other inquests that has been followed in few other countries. So, one is a coroner inquest or procurator system, procurator inquest. Another is medical examiner system. So, these are the common types of inquest that has been followed in other countries, but what we follow is police inquest, magistrate inquest and judicial inquest. So, what happens is that, let's take a case of murder or some death. Okay, so what will happen is that if somebody dies, they may die due to some pathological reason. So, just take that the person has died because of myocardial infarction and the doctor is certifying that death. So, now there is no suspicion, there is death certificate issued. So, no issue, the patient, they can take away the body and they will do whatever they want to do, like all the rituals and all they will do. But if it is a unknown cause of death, like somebody is found dead in their apartment, like nobody has seen what happened, nobody knows about his medical condition, they cannot determine what could have been the cause of death. Under such circumstances, what will happen is that it will be informed to the police. So, the police, they will come and they will investigate into the cause of death. So, they will do this inquest. So, police inquest is they will investigate into the cause of death. Along with the police, there will be few head of the village who will all be assisting the police in this investigation. Those are known as panchas. So, these are village heads. Like whatever the region they are in, there will be some head people, right? So, all those important reverend person, they will be assisting the police in the inquest. So, in the previous period, what used to be done is that there will be usually 5 people. We call them panchas. Since they are 5 people, we call them panchas, and along with the police, they will do the investigation and they will prepare a report. They will have an investigation report, and that investigation report is known as Panchnama. We call that investigation report as Panchnama. So, what happens is that once the police comes, they will investigate into the cause of death. If they are satisfied that there is no foul play involved, they will say the like there is no issue, you can take the body and you can do the rituals like that, they will leave at it. But if the police is having doubt, if he is thinking something foul could have happened, something suspicious could have happened, what will happen is that police, he will send the body for autopsy. So he will raise a requisition for post-mortem examination and he will send the body to us for post-mortem examination. This is how it usually happens. And this police who is doing this investigation, we call them as investigating officer. So we call them as IO, investigating officer. So this investigating officer, he will prepare a panchnama and he will send a requisition for post-mortem examination. This is how the body reaches us. We do not directly go and get the body for autopsy. The police only will bring the body to us to do the autopsy. Why? Because they want to know the exact cause of death, since they are not getting that through their investigation. So this is how the system usually works. So now the police has come, they have done the investigation and they have sent the body for post-mortem examination, and based upon the report they will further do the investigation. They will either close the case or they will investigate further depending upon the result. So this is the police inquest. Now what happens is that there will be certain situations where there will be need for higher scrutiny. Such cases will be done by magistrate. So we call that as magistrate inquest. So what happens is that what are those cases? It is usually asked. So example, you have exhumation, dowry death, then custodian death or rape. These are the cases where usually magistrate inquest is conducted. So what I mean by exhumation is that exhumation is lawful digging up of dead body, like somebody has been buried already, but now the police thinks that exhumation has to be done, that they have to be taken away and they have to do autopsy. Like that, if the police thinks, they have to get permission from the magistrate to do that. They cannot simply order exhumation by themselves. They have to get permission from the magistrate, then only they can do exhumation. So this is the first scenario. Second scenario is dowry death. So what we call dowry death is that whenever a married female dies within 7 years of marriage. So within 7 years of marriage, if she dies, especially under suspicious circumstances, if there is a suicide or death under suspicious circumstances, we take it as a dowry death. Irrespective of the history, irrespective of what people say about them, we will consider it as a dowry death only. Only after doing all the investigation, we will say it is not a dowry death. Just by somebody is saying that he is a very good husband, the family is a very nice family, we do not expect any sort of dowry torture from them. If somebody is saying, even if the relative of that female is saying, we cannot rule out dowry death. Only after thorough proper investigation, we can rule out that. So till that, every death of a female within 7 years of marriage, it is considered as a dowry death. And those dowry death, the inquest has to be done by the magistrate. So this is very important. They will ask you under which circumstances the investigation has to be done by the magistrate. So first is your exhumation, which involves lawful digging up of a dead body which is already buried. And second scenario is dowry death, that is a female within 7 years of marriage is dying, especially under a suspicious circumstances or suicide. So these are the two scenarios. Then you have one more thing that is known as judicial magistrate inquest. So first of all, we have to know what is the difference between an executive magistrate and a judicial magistrate. So judicial magistrate is someone who practices law. So he is someone who practices law, means he is a judge. So judicial magistrate is a magistrate. Like in the magistrate court, you will have the judges, right? Those magistrate, they will be called as judicial magistrate. Now executive magistrate are someone who is in an administrative post. They will be in that post due to some public service examination. They will be coming through this UPSC or some state commission examination. They will be in that administrative post. So those people, they do not practice law, but still we call them as magistrate. Like for example is your district magistrate, that is your collector, sub-collector, deputy collector, tahsildar, everyone, they will all come under these executive magistrate. So, sub-collector, tahsildar, everyone will be coming under this executive magistrate forum. So, you have judicial magistrate who practices law, and you have executive magistrate who are appointed in that administrative post. And why I am saying this judicial and magistrate, executive magistrate is that these judicial magistrate, they can only do this custodial death and rape inquest. What I mean to say is, if any rape or death happens under a custodial condition, that they are under police custody, they are in some sort of hostel school, or if they are in jail, any sort of custodial condition, if a death or rape happens, that investigation should be done only by the judicial magistrate. Not police can do, not an executive magistrate can do, only judicial magistrate can do in these circumstances. But this judicial magistrate, they can do investigation for exhumation, dowry death also. But these executive magistrate, they cannot do investigation for this custodial death or custodial rape conditions. So, this is the main difference. Do you get it? If it is a judicial magistrate, they can do for all sort of condition, but for custodial death and rape, only they can do. This executive magistrate, they can do for exhumation, dowry death, but not for this custodial death or rape. Police, they can do for all condition except for these three conditions, that is dowry death, exhumation, custodial death or rape. So, this is the main cases where which type of inquest is done. This is very, very important, and they will frequently ask you which type of inquest is conducted by these people. Who will do inquest in these cases, like that it is frequently asked, and what are the types of inquest also they will ask you. So, we have done police inquest and we have done magistrate inquest, and these are the only thing that is followed in India. Police and magistrate inquest is followed in India. In few other countries, they do this coroner inquest and medical examiner system. So, coroner inquest is that they will do investigation, like what is done by the police, they will do that, and they will also do the autopsy. And they will simply they will give the report and they will send it to the magistrate for further opinion. They will investigate and they will do autopsy. Medical examiner system is also the same, but he is having more legal value. He actually practices this. So, this both medical examiner system and coroner inquest is superior than our magistrate and police inquest. And between police and magistrate inquest, this magistrate inquest has more value than a police inquest. Clear? So, if they ask which is more superior in our setting, it is obviously magistrate inquest, and overall if they ask which is having superior value, then it is medical examiner system. So, this is how investigation into the death is done, and this investigation into the death, we call it as inquest. So, now we have seen the offence, we have seen the investigation. So, offence has happened, investigation has happened. Now, the matter must reach where? The court. So, we have taken the matter into the court. Court also we have divided them into criminal court and civil court. So, criminal offences, it will be dealt in the criminal court, and civil offences, it will be dealt in the civil court. And the civil court, you have your consumer forum, you have your all tribunal, green tribunal, all those tribunal, all those cases, it will be done in the civil court. So, all the monetary things, all simple offences, all those agreement legal issues, everything will be done in the civil court. And this criminal court, it mainly deals with more severe offences, and this criminal courts, they mainly have these. The hierarchy, it comes like this. It starts with the Supreme Court, which is at the apex. So, it is present in the national capital. So, the Supreme Court is the apex of our judicial system, and it will do cases only that has been appealed from the lower courts. From the High Court, the case will be appealed to the Supreme Court. This is usually the hierarchy, and beneath the Supreme Court comes the High Court, and this will be present in every state capitals. All the state headquarters, you will be having this High Courts, and after the High Courts comes your district or sessions court. It will be present in each district. And after the district or session court, you have the additional district or additional session judge court. Then you have the assistant session judge. Then finally you have the magistrate court. So magistrate court, the order comes like chief judicial magistrate, first class magistrate and second class magistrate. So this is the order from Supreme Court to the magistrate court. This is how the judges are in the hierarchy. This is how they are placed. And what we have to know here is that who all can give what punishment, that we have to know. So Supreme Court, any punishment, any like capital punishment, any period of punishment, means like they can issue life sentences. For any amount of time they can issue life sentence, and they can also award capital punishment, that is death. So this can be given by the Supreme Court judge, and fine can be given up to any amount. And this is the same with High Court judge. The District Court judge, they can also do the same, but except for one thing, that is the capital sentence, it has to be confirmed by the High Court. The District Judge, Session Judge, they can issue capital punishment, but it needs to be confirmed by the High Court Judge. Only then they will be doing that. So this is the main thing. So every amount, any amount, it can be awarded by these judges. Then comes your additional district judge. They are also in similar cadre with your district judge. So it is the same thing, same as above, and any amount can be awarded. And you have your assistant session judge. So they are assistant judge. So here what happens is that they can award only up to 10 years. So 10 years of sentence only they can award, and the fine amount, it is anything. So they can award any maximum amount of amount. And next comes your chief judicial magistrate. In the magistrate, he is at the higher hierarchy. So chief judicial magistrate, what happens with him is that he can award fine amount as anything. There is no limit for that. But in case of sentence, it can be only 7. So 10, 7, 3, 1. So 10, 7, 3, 1. Just reduce 3 from this, and after that put 3, then again it will be 1. So it starts with 10 and ends with 1. So 10, 7, 3, 1. You will reduce 3, then you will put 3, then finally you will end with 1. So you have to remember this, the sentences, like which amount, how many days they can award as the punishment. This is important. So chief judicial magistrate 7, first class 3, second class 1, or you can remember like to first class, opposite to that you will get 1, and opposite to second. So first 1, so second you get 3, 1, 2, 3, opposite that you get 1. Like that also you can remember for chief judicial magistrate, remember CR7. So C for chief judicial, CR7, Cristiano Ronaldo number 7, like that you can remember. And the fine amount also we need to remember. Here it is 10,000 and 5,000. So first class you will put 10,000, second class 5,000, like that we have to remember. So here what they can ask you is, if it is a viva, they can ask you who all can award capital punishment and who cannot award capital punishment, like that they can ask. And they may specifically ask you what is the punishment that can be awarded by this magistrate and who is high up the order, like that they can ask you. So this is how the court works, and this is how the judges work. What is the punishment that can be awarded? That is important. So now we have entered the court. So in court there will be court proceedings. So we call it as court proceeding. What happens is in the court, how it happens in the court, that is what we are going to see now. So in case of court, what will happen is that when a case enter a court, when they file like some writ petition or when they take up the case, what will happen is that they will initially look what is needed for the case, like who all need to come for the evidence. First they will look at that and they will send summons to the evidences. So this summon is known as subpoena. Okay, so subpoena means under warrant. So sub means under, subpoena means warrant. So subpoena means under warrant. Like they are under the obligation, they have to come to the court. It is a legal warrant. So summon is actually a warrant. If you fail to visit the court in spite of giving a summon, you can be punished. It can be either awarded a fine or sometimes a 6-month sentence can also be awarded. So, subpoena means you are under warrant to appear in the court. So, this is what summon means. And when we say summon, it can be of two types. One is subpoena ad testificandum and subpoena duces tecum. These are the two types of summon that is usually given in our country. So, what happens is that when they call you to the court, they can ask you to give only evidence. So, this is only for evidence, that is only for testifying. We call it as subpoena ad testificandum. You will go there and you will say whatever you know about that offence, whatever you saw or whatever you experienced, you tell about that. That is subpoena ad testificandum. Next is subpoena duces tecum. Duces means two. So, here what happens is that you have to go along with documentary evidence. So, along with the documents, you have to testify. So, this is the subpoena duces tecum. So, these are the two types of subpoena. One type where you have to simply go and testify. Second type where you have to go along with the documentary evidence and give testification. And this is what we usually do with PM reports. So, what usually consists of a summon is that they will issue a summon in your name. So, they will ask you that you have to appear on this court on this time on this day, like they will give the particulars, and they will also give what is the crime number and what is the name of the accused and what is the crime, the which penal code it is coming under, like that they will give the details and they will issue a document. So, normally what happens is that it will be issued by the presiding officer in the court, usually the judge. They will issue the warrant and it will be given to you by either a police officer or a court official. This is how it is usually given. And if you are not present in that city, in that place, what they will do is they will send it to the magistrate of that area where you are residing. They will send it there and that magistrate, he will serve you the summon. And if they are not able to find you, what they will do is they will come and look at your office. If you are a government servant, they will come to your office and they will serve it to your higher official. Like if I am working in a medical college, if they couldn't find me in my address, whether it has been a temporary address, if they are not able to find me, what they will do is they will try to find where I am working. So, if they find out that I am working in a medical institute, they will come to my medical institute and they serve it to the dean or my HOD. So, department head or the institute head, they will serve it to them and they will get signed in the duplicate. So, it is usually 2 documents is given, like 2 copies. So, in duplicate, we have to sign and we have to preserve the original with us. So, it will be 2 copies. Duplicate, we have to sign and give it back to the person who is delivering the summon, that we have received the summon, like that we have to write and we have to put our signature along with date. So, we will return the duplicate and we will keep the original. So, if I am not found in my address, they will send it to the working place. Even if they are not able to find out my working place or myself, what they will do is they will give it to somebody from my family. Like if they are not a servant, like it usually given to a family member. If some servant is picking up the summon, it is not valid. So, what they usually do is they will give it to a family member. And even if the family member is not available, what they will do is they will simply paste the summon over the front of the house and they will say that summon has been delivered. So, this is how it is usually done. So, it will be either given to you directly by a court official or police official, or it can be sent to you by a registered post. If you are in some other city, they will send it through the magistrate of that area, or they can be given to the head of the institute where you are working, or it can be given to your relative, or it can be pasted over the front of your house. So, all these ways summons can be sent and they are all considered valid. So, after doing all these things, if they have received the summon and someone is not attending the court, the court can actually award punishment because they are under warrant. They have to go to the court. If they fail to do so, they will be punished by the judge. It can be either a fine, it can be a warning, or it can even be imprisonment. So all this thing can be done by the judge. So this is the main thing about summons. And whenever you visit a court, you will be given some sort of travelling allowance. That is your conduct money. So the expenses for visiting the court. The expenses for visiting the court, you will be given some sort of conduct money, and this conduct money, it is given only in civil cases, not in criminal cases. So this is very important. If it is a criminal case, conduct money is not given, and if you are a government servant, what can happen is that you can get a certificate from the court that saying that I have attended the court under this judge on this day. Like that, you can get an attendance certificate from the court and you can present it in your institute to get some sort of allowance. So this is how the conduct money works. Usually it is given only for civil court and it is not given for criminal court. Why? Because in case of criminal cases, it is your duty to assist the state. So to assist the state, you are going to testify in a criminal case. So in that cases, you cannot be getting conduct money. And there is one more thing with subpoena which is important, is that like sometimes what will happen, you will get subpoena for 2 different cases on a single day. If that thing happens, what you have to do is, if it is a higher and lower court, you have to prefer a higher court, meaning you get subpoena from a district court, you get subpoena from a high court, and both the thing are on the same day. You have to go attend the court on the same day, same time. Then what you have to do is, you have to attend high court. You have to prefer high court over the district court. If it is a difference of criminal or civil offence, if it is a criminal offence or civil offence, in such cases what you have to do is, you have to give preference to criminal offence over a civil offence. And if both the courts are same, if both the cases are criminal offence, in such cases what you have to do, you have to attend the court which summon you received first. So you receive the summon first, like you are getting order from 2 high courts to attend the court on the same day for a criminal case, like 2 different criminal cases. So in such condition, what you have to do is, like if you had received order from the court A prior to court B, then you have to go to court A first. After that only you can go to court B. So this is how the order of appearing in the court done. So subpoena or summon, clear, right? So subpoena you have ad testificandum and subpoena ducis tecum. Testificandum only testify, ducis tecum you have to carry the evidence along with you and testify. And conduct money is something that is usually given for attending civil courts. So this is how subpoena is done. So case has been done, it has been put up in the court and court has sent the warrant. Now comes the court procedure. Actually what happens in the court? So in court it can be divided into witness, evidence and the lawyer questioning. So these are the 3 things that happens in the court. So first we are dealing with witnesses. When we say witness, you can have 2 type of witnesses. One is a common witness, another is an expert witness. The main difference between common witness and expert witness is that the common witness, they use the principle of first hand knowledge, while expert witness, they will use their expertise. They are expert in some sort of field. They have some peculiar different expertise knowledge in a field that qualifies them to be an expert witness. The thing about this expert witness is that they can be both. They can be a common witness and they can be an expert witness. But this common witness, they can only be common witness and not become an expert witness. So these are the 2 type of witnesses that we commonly see in the court. So when we say common witness, this common witness is someone who had experienced the actual offence. through their sense, like they could have either seen the offense, they could have heard about the offense, like that they have actually experienced the offense, and they will come and state whatever they know about the offense. This is your common witness. Now, expert witness is someone who can draw inference and give opinion on the witness statements. Like the witness, they will say something. The witness, common witness, they can say that I saw a AK-47 killing that person. Like that the common witness will come and say. But this expert witness in this case would be a ballistic expert or some autopsy expert, like forensic surgeon can also be the forensic this expert witness. So they can get an inference, like they have seen the body, they have done some examination, and by looking at the nature of the wound and looking at the condition of the body, they can say that this was happened by AK-47 or not happened because of AK-47. Like they can draw an inference, they can give an opinion upon the statement given by the common witness. So this is how this expert witness works. They have a special knowledge on a specific area and they can give their expertise. They can share their knowledge in the court and this will be accepted by the court. So this is expert witness. And here these expert witness, they can be common witness also. For example, if a forensic surgeon, if he comes and gives the autopsy report, he is an expert witness. But second day, if he comes and talks about some other crime that he had witnessed while going in a road, if he saw someone shooting someone else, then in such case, he can be a common witness also. This is how this common witness and expert witness works. The main thing you have to remember is that common witness works on first-hand knowledge, while the expert witness, he draws inference and forms opinion based upon his knowledge and experience. So this is the main type of witness. Apart from that, there are few other peculiar type of witnesses that is available. You have a hostile witness. So hostile witness means what happens is that the person, the witness who comes first time, he will say that let's take a scenario. Like a person A, he is our common witness and he is saying, I saw Akhil, just take a name, like I saw Akhil kill Varun. This is his first statement, and after few other rounds of questioning, after few other days, in another hearing, he will turn his statement. So he will turn his statement. So he will say that I did not see Akhil killing Varun. I did not even see Varun at all. Like that he will turn his statement, which usually cause some adverse effect to the plaintiff's case. So what will happen? He will be supporting one side and giving evidence initially. And next time what will happen? He will turn his own statement which will affect his agent. So this is how this hostile witness happens. He can either lie first time or lie second time. That does not matter. What happens is that he simply turns his statement. First time he will say one thing and second time he will say complete opposite thing. So this is your hostile witness. There is something else known as perjury. This is something where there is a willful lying under oath. So here there will be willful lying by the witness under oath. So he would have taken the oath. In the court of law, he would have taken the oath saying that he will say only the truth, nothing but the truth. But still, even after taking that oath, he will give false evidence. So this perjury, this is the crime and there is punishment for this perjury when proved. So this is willfully lying under oath. So hostile witness is someone who simply turns his statement. Perjury is willfully lying under oath. So this is the main difference between this hostile witness and perjury. So witness, common witness, expert witness, hostile witness and perjury. So this is about the witness. So next to witness, what we have is evidence. So evidence, depending upon where it is done, it is divided into two. How it is like acquired outside the court, how evidence is acquired. Based upon that, it is direct or indirect. So outside the court, it is acquired either directly or indirectly. So directly means they have experienced themselves. So this is someone witnessing the murder through their own eyes. This is direct evidence. When they come and testify, we call them as a direct evidence. And indirect evidence is circumstantial and hearsay. These are the two types of indirect evidence. Here what happens is that they do not directly experience the crime. They do not see it or hear it. What they would have seen is a circumstantial circumstance where they can confirm that the crime would have happened. So we will take an example. What happens is that, like, there is one wife and one husband. So this wife, she is planning to kill her husband, and what she is doing is that she will go to one pharmacy and she will buy a rat poison and she feed it to her husband, and the husband dies. And in the autopsy report, the report is coming that the person has died because of rat poison. So now what we know is that from the outside, what we know is that the husband has died suspiciously and the postmortem report is coming as this rat poison. So now while we do the investigation, there might be nobody who has seen the poisoning done by the wife. So they don't know whether the wife gave the poison or not. But there will be one person who have seen the wife buying this rat poison. On the same day, the husband had died. So now that person who saw the wife buying the rat poison, he did not see the wife killing husband directly. What he saw was only the rat poison. So here you can connect the crime. So that day he had seen her buying rat poison, and the same day the husband has died because of rat poison. If you can prove other things, like the husband did not eat it accidentally, the husband did not eat it himself for some suicide. So if you could prove these things, then this person who is giving this rat poison history will be considered a circumstantial evidence. Clear? Here that person did not see the wife kill husband. What he saw was only her buying rat poison. And based upon all other circumstances, if it comes to the wife's suspicion, then we can say that this is a circumstantial evidence which can prove the wife guilty. Clear? So this is indirect type of evidence. Now you have another thing, that is hearsay. Here what happens is that, take the same case. Here this person, he did not even see her buying rat poison. But what he saw was this wife talking to someone else saying that I killed my husband finally and I am finally free. Like that wife is talking to somebody else. He hears this conversation. So here he did not even see her buying rat poison, did not see her killing the husband by feeding the poison. But what he heard was that wife boasting to someone that I killed my husband finally. That history he heard. So here it was only a hearsay, that he heard that person admitting to the crime to somebody else. So the witness, they will hear the accused admitting crime to somebody. So this is hearsay. So it is kind of circumstantial, but since he is hearing, mainly it is a hearsay. So this is how indirect evidences comes about. Indirect, when it is done circumstantially or hearsay is done, we call it as these. And direct is, they will experience themselves. If the person, he had seen the wife mixing the rat poison in the food and feeding it to the husband, then that is a direct evidence. And if he heard only her saying about this to somebody else, it is hearsay. If he see her buying only the rat poison, this is circumstantial evidence. So this is how the evidence is acquired outside the court. Inside the court, we get two types of evidences, that is oral and documentary. So oral is, they will simply come and say that I saw her killing her husband. This is oral evidence. Documentary evidence, what they will do is like PM reports, ballistic report, or your wound certificate. All these are documentary evidences. When you produce a document like some sort of reports and you give testification about that thing, then it will be considered as a documentary evidence. So, we have seen the offences and we have seen the inquest, we have seen the court, and court we have seen the warrant, witness, evidences. So, these are the legal procedures that we need to be familiarize ourselves with. So, evidence is done. Then what happens next is that there are certain special type of evidences we have to know. One such evidence is dying deposition and dying declaration, and this is a very important thing they will ask in the exam. So, dying deposition, the first thing that we have to make clear is that it is not done in India. Only dying declaration is done in India. So, what the concept behind this dying thing is that they will assume that the person who is going to die will always speak the truth. So, there will not be no oath. So, oath will not be done, and there will not be presence of any accused lawyer. So, this is not necessary. They can be present, but it is not mandatory. And cross-examination, it is not done. It has legal value only if the patient dies. If he survives, it will be taken more as a corroborative evidence. Based upon all other evidences, then they will give the final judgment. So, this dying declaration, it can be recorded by anyone, even a nurse or doctor can record, but preferably by a magistrate. Executive magistrate can also do. So, this is dying declaration. So, a person who is going to die will not lie. That is the concept behind this dying declaration. But this dying deposition, which is being followed in few other countries, what they will do is, this is recorded only by a magistrate. Only a magistrate will come and take the statement, and oath is administered. There will be administration of oath, and there will be presence of accused lawyer, and cross-examination will be done, and this has more legal value. Even if the patient survives, this has more legal value than the dying declaration. So, this thing is important. They will ask you what is the difference between a dying deposition and dying declaration, and how it is usually done, under oath or not, cross-examination done or not, like that they will ask you. So, this is one type of evidence that we have to know. And order of court proceedings. So, how this is usually done, that we have to know. So, first thing is that whenever a court starts, when the judges starts investigation, what they will do is they will administer oath. So, first comes the oath. After that comes your examination in chief. So, next comes your examination in chief. This is usually done by the public prosecutor, and after examination there will be cross-examination, and this is done by the defense lawyer, and after this cross-examination you will have re-examination. This is how the court proceeds, and there will be lot of questions asked in the court. And one important question that we have to know there is the leading question. So, leading question is something which can be answered only by saying yes or no. It will be like, did you witness the murder? Yes or no. It will be that kind of question. So, you can either say yes or no. Those kind of question are known as leading question. You cannot explain any further. You have simply can answer either an yes or a no. This is the leading question, and this question, it is asked only in cross-examination. It is not allowed in case of this re-examination or examination in chief. So, what happens is that why we call them this leading question is, this will be like, these questions will be asked in a order where they will lead you to some point. They will keep on asking yes or no. Did you witness it or not? Did he was carrying the knife or not? Did he use a gun or not? Did you see him at that point or not? Like that they will simply keep on asking you yes, no, yes, no, yes, no. And without knowing, you will be led to a point where they will make you say what they wanted. So it is usually done by the defense lawyer. He will make you say what he wanted you to say. He will try to break your case. That is where he will lead you to. So these kind of questions are known as leading question, and this is done only in cross-examination. There is one more place where this leading question can be asked, which is when a witness turns hostile. When a witness turns hostile, you can do this in re-examination. Hostile witness means he was your witness, he was favorable to you. Initially, he gave an evidence which is favorable to you, but when he was re-examined, he will turn his statement. So, he will say something against you. So, in such case, you can tell the judge that he has become hostile, and if the judge feels that he is actually a hostile witness, he will declare him as a hostile witness. Under such circumstances, you can ask these leading question in re-examination. Clear? So, this is the type of question that is usually asked. So, what happens is that they will be given oath and examination in chief, where the public prosecutor, they will ask you to explain what all you know. Whatever you want to say, he will ask you, like whatever you know about the crime, just tell me about that. What happened on that night, tell me about that. Like that he will ask you, and you can give your whole narration. You can give all the evidence, you can give all the details. That is your examination in chief. And once the public prosecutor is done with you, then comes your defense lawyer with the cross-examination. Now he will start asking you these leading questions. He will ask you yes or no, and you will keep on saying either yes or no. And he may break your case with these leading questions. If he has broken your case, then comes a re-examination, which will be done again by your public prosecutor. That is your side lawyer. He will again do the re-examination. In that re-examination, he will try to re-establish the fact which has been destroyed by the defense lawyer. So, this is how a court proceeding actually works. So, after finishing all these things, all these proceedings, the judge will come to a conclusion and deliver a judgment. So, this is how court proceeding happens in our country. So, this is the important thing that we have to know in the legal procedure, starting from the definition of forensic medicine, medical jurisprudence, then going to the type of offences like cognizable, non-cognizable, criminal and civil offence, then going into the inquest, types of inquest, magistrate, police, and which all cases can be done under magistrate inquest, especially executive magistrate and judicial magistrate, the type of inquest that is done in our nation. Then what is the thing that is followed after inquest is your court, the hierarchy of the court, the punishment that can be awarded by the court, and the subpoena or the summon that you receive from the court which warrants your attendance in the court. And in the court, what happens, who are all the witnesses, what are the types of witnesses, and who are all the evidences, how the evidence is presented in the court, and how actually the proceeding happens in the court. All these forms the legal procedure part. We are done with the legal procedure. Now we are going to see the medical law and ethics. So till now we saw how legally how things happen, like what happens outside the court, what happens inside the court, all these things we saw till now. So now what we are going to see is medical law and ethics. Like what are the medical principles that we have to know as a medical personnel, as a doctor practicing medicine, what all the things that we have to know, the legal procedures that we have to know. So first thing is the very important consent. So, consent is an agreement or a legal contract between doctors and patient. So, when we say consent, it means a contract that is legally valid, an agreement between a doctor and a patient. And this consent, it forms a most important part of the practice. So, whenever you are seeing a patient, this consent is very, very important, and this consent has to be a valid consent. To say something as a valid consent, there are few things that we have to fulfill. So, first is the age. They have to be above 18 years of age. If it is some life-threatening procedure, like you are going to do some surgery, under that condition, you have to get consent only if the person is above 18 years of age. To be called a valid consent, the person has to be above the 18 years of age. If they are not above 18 years of age, you have to get consent from the parents or the legal guardians. Only then it will be considered a valid consent. If it is a simple physical examination, then more than 12 years of age is enough. 12 years of age is for physical examination. And life-threatening procedures, surgeries, they need to be above 18 years of age. So, this is the age limit for a valid consent. Apart from that, the consent has to be clear, direct. It should be in a language, like native language, that is understandable to the patient. You cannot use all the medical terms. You cannot say that I am going to perform tracheostomy, I am going to perform appendicectomy, laparotomy. Like that you cannot say to them. You have to explain it to them to their knowledge. Like if they are speaking only English or if they are speaking only Hindi, in that language you have to explain it to them in simple terms so that everybody can understand. And that also has to be directly addressed to the concerned individual. You cannot like say it to a nurse and nurse will go and get consent like that, or you will say it to a relative and the relative will go and get consent from the patient. Nothing like that. You have to directly address the patient and you have to tell them all things. It should be an informed consent, means you have to tell them about all the pros and all the cons, like what will happen if they do the surgery, what are the expected complications from the surgery, and what will happen if they don't do the surgery. All the pros, all the cons, everything has to be informed to the patient. And after all these things, if they give you consent, then it is known as a valid consent. And if they refuse you, it is known as informed refusal. So, if they give consent, it is known as informed consent. If they refuse after saying everything, after explaining them everything, it is known as informed refusal. So, this is the basic of the consent. To be called something as a legally valid consent, the age criteria has to be fulfilled. It should be informed, like all the information, all the pros and cons should be said directly, clearly and in a language that is understandable to them. All this thing has to be fulfilled to call something as a valid consent. So, this is the first part. Now, coming to the type of consent. You have implied consent or expressed consent. This is the main type. So, implied consent is not verbally given. So, here consent is there, but it is not verbally expressed. So, how it happens is that you are running a clinic and somebody is coming to your clinic and getting a token, like they are paying a fee and they are getting token and they are waiting in the line to see you. So, when they comes to you, you will not ask them like whether you are consenting to get treatment from me, whether you are consenting to say all your medical history to me. Like that you will not ask them. You will simply start treating them. You will ask for the history and you will start treating them. So, those kind of thing is known as implied consent. Means the act of coming to your clinic, getting the token and waiting in the line to see you means they want to see you. They are giving consent to see you, but they are not explicitly expressing it, but they are expressing it through their act. So, this is known as implied consent. Here nothing will be expressed very externally or explicitly, but it will be understood. So, this is known as implied consent, and opposite to that is your express consent. Here everything will be explicitly given. Like it can be either a oral or written consent, that they will say by words, like I want to be get treated by you and I give you consent, like that they can say. Or they will write it and give it to you, like I want to be treated by this doctor and I give consent, like that they will write and give consent. So, these are the two type of consent that is seen in expressed consent. Between these two, the more valuable is the written consent. So this is having more value because it can be reproduced in the court or somewhere. If there is any issue, we can reproduce this consent. So this is the main types. First is your implied, where nothing is expressed, and next is your expressed consent, where the consent is given either verbally or by writing it down. So this is the main type of consent we have to know. And there are few other consents that we have to know about. First is your blanket consent. So here what happens is that this is usually done in few countries. What they will do is, they will get a consent that covers everything. They will write like I give consent to all the procedure the doctor wants to do with me. Like they will simply give consent for everything, all the procedures, all the investigations, all sort of things the doctor wants to do, like what they want to do medically for the treatment of the patient, they will do. If they see something is fit for the patient, the doctor will take the decision himself because they have already given the consent. This is a blanket consent, and this is not legally valid in our nation. So it is not legally valid in India, because we follow the concept of informed consent. Each and every procedure we have to get consent from the individual, except in case of emergency. If it is an emergency, then you can do which is the best thing for the patient. But if it is not an emergency, you have to get an informed consent from the patient, then only you will be able to proceed. So first is the blanket consent, which is not legally valid in our nation. So next what you have is proxy consent. So proxy consent is something that is given in place of someone else, like putting proxy attendance. So it will be given in place of another one. So here this is, if we say we told that 18 years the legally valid age where you can give consent for surgical procedures or life threatening procedures, right? So if the person is less than 18, then what we will do, we will ask consent from the parents. So they are giving consent on the behalf of that child, right? So this kind, one giving consent on behalf of other, this is known as proxy consent. And next what we have is loco parentis. This is also kind of proxy consent, but here what happens is that in the place of parent, teacher or warden, they will give consent. So what happens is that, like if someone is going on a picnic or if someone is staying in the hostel and some procedure has to be done to them, some life threatening procedure has to be done, very emergency, it is an emergency and it has to be done. What we usually have to do, if they are less than 18 years, we have to get consent from the parents, right? But if the parent is not reachable, if the parent is not available, then what we can do is, we can get consent from the in charge teacher or the warden. With their consent, we can proceed with the procedure. So this, in place of parents, if someone is giving the consent for the individual, then we call it as loco parentis. So these are the other types of consent that we have to know. First is blanket consent, next is proxy consent, and finally your loco parentis. And informed refusal is something very important nowadays, because nowadays people are fighting for negligence cases. So they will say that the doctor did not explain all the cons to me. He did not say that I will get something adverse if I don't follow the treatment properly. Like that the doctor did not say, so I want to put a negligence case against him. Like that, lot of people will do that. So to fight against that negligence, you have to get informed refusal. Let's take an example. If someone is coming, they are coming with some lump in the breast. So they aren't very old, like they are 40 plus. And what you advise, you will ask them to do further investigation, like you will ask them to mammography. But they are saying, no, this is nothing will happen to me. Like that they are saying. But you are keep on insisting that this can be dangerous, this can be a malignancy, like it can be a tumor, you have to get it checked out. Like that you are explaining it to them. But even after listening to all, they are still refusing. You are just letting them go. After a few years, they are coming with some advanced stage of breast cancer. Now what they will do? They will go to the court. They will tell them that the doctor, he did not tell me about all the thing about that lump. He did not insist that I have to do investigation properly. Like that, he did not mention it to me. Like that, they will put a case against you. And in that scenario, if you had already taken this informed refusal, then you can prove it in the court that I did give all the advice, I did give them all the cons, but still they refused. You can prove it in the court. That is the important thing about this informed refusal. It is mainly to protect you against all the negligence suit and all. So, this informed refusal is as much as important as the informed consent. But this informed refusal, it has to be completely informed. You have to tell them all the pros, you have to tell them all the cons, and you have to tell them what will happen if you don't go ahead with the procedure. Everything has to be detailedly and properly explained to the patient, and even after that, if you are refusing, you can get this informed refusal. So, this is the main part in the consent. So, what is the legally valid consent and what are the types of consent, and for what all procedure you can take express consent, that is important here. Now, I have one question. So, somebody is coming to your clinic and you have to perform some invasive examination, like you want to do some PV. In that scenario, what you will do? Whether implied consent is enough or you have to get express consent. So, here since it is an invasive examination, you have to get expressed consent. If you want to take a blood, it is an invasive procedure, you have to take express consent separately. If you are doing ultrasound, that is a non-invasive procedure, right? So, implied consent itself is enough? No, not like that. Even if it is a non-invasive procedure, ultrasound is a major procedure. So, for that you need proper consent from that patient. Only after getting these consent, you can go ahead with the investigation. So, this consent is very, very important, and this consent itself can be asked as a short notes. So, next what we have is medical indemnity insurance. So, medical indemnity insurance is an insurance. So, like your health insurance, life insurance, this is basically an insurance against negligence suit. So, against negligence cases, like if someone is putting up a negligence case against you, you have to fight them in the court, right? So, all the expenses that is caused because of this case, this insurance company, they will pay you. You have to pay premium, like how usually insurance works, you have to pay premium, and if in turn any case comes against you, they will help you pay for the court expenses. So, this is the medical indemnity insurance. Next what we have is euthanasia. So, euthanasia is mercy killing. It is mercy killing. So, what happens is that euthanasia, it can be either an act of commission or act of omission. So, here what they usually do is they will do something active. So, this is also known as active euthanasia. They will give some lethal injection and they will kill the patient. And omission is passive, passive euthanasia. Here they will simply remove the life support, like oxygen support they will remove, or they will withhold the IV fluids, the nutrition basically what they are giving, that they will be withholding. So, this is the main type of euthanasia that is usually done. And in India, only this passive euthanasia is allowed. Apart from this active euthanasia, it is not allowed. So, what happened is that even before one case, this passive euthanasia is not allowed in our country. What happened was this, there was this one Aruna Schonberg case. So, this lady, this Aruna, she was under vegetative state for a very long time, like she was raped and she was hurt very badly and she went into coma, and she was in that coma stage for a very, very long time. So, what happened was that she was undergoing lot of stress. She was in coma and they kept on treating, but there was no use. So, the people, they started arguing that instead of letting her suffer like this for a lot of years, they should let her die peacefully. Like that they argued, and this case went to the court. So, the court ordered that it can be done to reduce the pain of that patient. It can be done, and it can be only done in this passive way. They cannot give actively any lethal injection to kill that patient. They can only passively, mercifully kill that patient, like that the government court ordered. So after that case, the passive euthanasia was allowed in our nation, and even for that passive euthanasia, you have to get consent from the legal guardians, like the parent or spouse or close relative, whoever is available. That legal guardian have to give consent, and the treating doctor have to give consent. After that, it can be taken up to the court, and the court, it will appoint a board of doctors, and only if the doctors give commission, like if they give consent, then only we can do this euthanasia. And only passive euthanasia can be done, not active euthanasia. And there is something known as voluntary euthanasia. So here what will happen is that the patient themselves, they will voluntarily go and they will ask to be done euthanasia. So here this is, they will people with some life-ending diseases, very grave diseases, what they will do is, instead of suffering from the disease, they will ask to be killed. So this is voluntary euthanasia, and this is not done in our country. Only passive omission euthanasia is done in our country, and this euthanasia, it can be asked as a short notes. And next to that, we are entering the important part in the medical ethics, that is professional misconduct, or known as professional or ethical negligence. So you have ethical negligence and professional negligence, two entities. So this is one entity and this is another entity. So this ethical negligence, it is also known as professional misconduct. So here what happens is that the doctor will commit a crime. He will commit an act which is morally wrong. So something that is ethically or morally wrong, if he has done something, we call it as this professional misconduct or ethical negligence. And usually this is something, mostly this consists of something where there is no punishment in the law. Only something that is ethically wrong, it will be dealt in this professional misconduct. There are few things that overlap, but mainly professional misconduct or ethical negligence, it deals with the morally or ethically wrong things. And this 6A is very famous for this professional misconduct. All the 6A's is alcohol, treating a patient under the influence of alcohol, abortion, performing illegal abortion, adultery, having an inappropriate relationship with the patient, then advertising. So putting up an advertisement for himself, or association with unqualified individuals. That is procuring quack or some people for getting commission, like they will bring patient to you and after that you will get commission from them, like that, those kind of association with unqualified individuals. And finally, addiction, like they may be addicted to some substances or they may sell substances that is addictive in nature. So these are the main 6 A's of this ethical negligence. Apart from that, you have a lot of things like taking bribe, issuing false certificate, conviction in court of law, then dichotomy, that is fee splitting, like they will refer to lot of doctors and they will get commission, they will split the fee unnecessarily, they will be referring. So all these conditions will be coming under this ethical negligence, and this ethical negligence, it can be compliant to the medical council. So your medical council will deal with this ethical negligence, and if found guilty, they will be issued a warning notice, and if they keep on doing that, there can be erasure of the doctor's name from the registry. So this permanent erasure, this is known as penal erasure. When they permanently remove your name from the medical registry, we call it as penal erasure, and this is the highest punishment that can be awarded for this ethical negligence, and it is usually done by the medical council. So, this is the main thing about this ethical negligence. This is something morally wrong, and main 6 is with professional misconduct is this: alcohol, abortion, adultery, advertisement, association with unqualified individuals, addiction. Apart from that, you have getting bribe, issuing false certificate, conviction in court of law, then dichotomy. These are the most common professional negligence or ethical negligence that can be seen. So, next what we are going to see is professional negligence, which is very important topic. This can be asked as an essay or short notes, and this is a must know topic not just for examination but also for your general practice. So, when we say professional negligence, what we mean by that is that there is an absence of reasonable skill and care by the doctor in treating the patient. So, this is what professional negligence is. So, what they usually do is they will either commit something that one is not supposed to do, or they will not do something one is supposed to do. So, this is what basically happens. They will do something one is not supposed to do, or they will not do something one is supposed to do. This is your professional negligence, and this professional negligence, this is a very grave issue, and this can range from small to severe damage to the patient. There can be even death of the patient. So, this professional negligence chapter is very important, and to say something as a professional negligence, we have to fulfill 4 criteria. So, we call them as 4 Ds. So, first D is duty. You have dereliction of duty, which results in damage to the patient, and that damage, it has to be a direct causation. So, when all the D's are fulfilled, then only we call it as a case of professional negligence. So, there has to be a duty between the doctor and the patient. Clear? That is first. Then dereliction of duty means something wrong was committed. There was some lack of skill or lack of care. Some dereliction, something that is abnormal has been done by the doctor, and because of the dereliction, there should be direct resultant damage to the patient. That act of commission or omission directly caused some sort of damage to the patient. It can be either a small damage or it can be even death. So, there has to be some sort of damage. Even if one is not present, then we cannot say that it is a case of professional negligence. So, for example, if a patient is coming to you and from the starting itself, he is coming to you in the OP and he is not ready to pay any fee to you, he is not even ready to take the token. So, you directly send him away. You are saying that I don't want to treat you since you are not giving me fee, and it is not an emergency condition. So, you are just sending him away. So, now if the patient don't go anywhere else and they are getting some complication because of their condition, now he cannot say that I came to your OP, you did not treat me, because of that I had this damage. He cannot quote like that because you did not treat him. There was no doctor-patient relationship between you two. That was not at all established. So, there we can always quote that there was no negligence because he is not my patient. So, this duty was not established, like that you can always say. After that, what you have is dereliction of duty. If someone comes to you and you admit him and you start treating him, you treat him properly, you do all the procedures properly, you care for him properly, But even after that, he is getting some damage. That case, you are not responsible. That is something adverse had happened even after doing everything perfectly. So that thing, even there is a damage to the patient, you cannot say that was a negligence of the doctor. So damage has to be there and it has to be done because of the error by the doctor. So every single criteria has to be fulfilled, and this direct causation means like there is dereliction of duty and there is some damage in the patient, but that damage was not caused by the doctor's fault. It happened because somebody's fault. For example, the doctor, he did not give antibiotic to an open wound, but the patient, he went to home and he put lot of cow dung or soil over the wound, and because of that he had sepsis. Now, not giving antibiotic was doctor's fault, but still if left as it is, the wound would have cleared up on its own. It would have healed on its own, but the patient complicated the things further by putting all the cow dung and all the soil over the wound. Here the patient did something which directly caused his illness. Like the patient had septicemia, the patient had lot of complication because of that septicemia. So that dereliction of the duty did not directly cause this injury to the patient. Because of the patient's own negligence, that illness and damage was incurred by him. So here there was no direct causation, so we cannot say that it was a negligence by the doctor. Like that, each and every criteria has to be fulfilled by the doctor to call something as a case of professional negligence. Clear? So definition of negligence is very important, and what are the 4 Ds that comprises the professional negligence, that is also very, very important. Now coming to the type of negligence. You have type of negligence. First we have your civil negligence and criminal negligence. So here what happens is that mainly depending upon the nature of the damage, we divide them into this civil and criminal negligence. So first, if the damage is less severe, we call it as civil negligence. If it is more grave damage, it is a criminal negligence. So what do we mean by this grave damage? Like loss of limb or loss of life, all those called as the grave damage. And less severe, like they had to be admitted for a few more days, they had to be under pain for a few more days. Those kind of things we cover under this civil negligence. The main difference between these two is that this is fought in a civil court or consumer forum. So this is the next difference. But here criminal negligence, it is fought only in criminal court. And here it will be patient versus doctor. But in case of criminal negligence, it will be state versus doctor. So the state will take up the case against the doctor. So it will be public prosecutor arguing against you. So public prosecutor arguing against the doctor. And here the one important thing is that like the degree of proof need not be 100%. But here they have to prove it 100%. That there is no other way they could have suffered this damage in case for the negligence of the doctor. Like that they have to prove. So this 100% proving the negligence is important. And if the punishment is awarded, if proven guilty, here it is mostly fine, but here it can be imprisonment with or without fine. And also the most important thing here is that patient negligence or contributory negligence, like contributory negligence, patient negligence, we will see later on, and informed consent. This is a defense. This can be taken as a defense, while in case of this criminal negligence, it cannot be taken as a defense. So this is the main difference between this civil negligence and criminal negligence. So civil negligence, criminal negligence, Are we clear with this? Because this is a very important question, very important difference that we have to know. This is frequently asked. Here the main thing that we have to highlight is this. It is a patient versus doctor thing, while this is a state versus doctor thing. Here you will have only fine, while here it will be imprisonment along with fine. And here patient negligence, that is your contributory negligence, informed consent can be taken as a defense, while in case of criminal offence, it cannot be taken as a defense. So, this is very important to know. So, we are done with two types of negligence. Next, what we are going to see is patient negligence. So, patient negligence I have told you already. So, here it is not the doctor who is negligent, but the patient. So, what happens here, like doctor will advise for the antibiotics for a wound, they will not follow the instruction properly, they will not take the medicines properly, they will do their own native treatment and they will end up losing their limb. Here the doctor was not negligent, it was the patient who is negligent. So, these kind of negligence we call it as patient negligence. Now comes the fourth type, which is contributory negligence. So, here what happens is that here both patient and doctor, they are negligent. So, the same case, the doctor advised antibiotic but the patient did not take, it is patient negligence. If the doctor did not advise antibiotic and the patient also did not follow any instruction by the doctor and ended up with septicemia, here both doctor and the patient are negligent. So, we call it as a contributory negligence. And if it is a civil negligence, what will happen is that they will compare whether patient is more negligent or doctor is more negligent. Comparing the degree of negligence, they will award the monetary fine. So, if it is more on the patient side, the doctor's fine will be less. If it is more on the doctor's side, the doctor's fine will be more. So, depending upon that, they will decide. So, this is your contributory negligence. And next what we have is composite negligence. Composite negligence. So, here what will happen is that two or more doctors when they are found negligent, two or more doctors when they are found negligent, we call it as composite negligence. So, this is how it happens, like they will come to you with some kind of trauma and you will look at the external examination and you will decide that there is no fracture. You can simply go and take the painkillers, the pain will settle and you can be free, like that you are telling them. But after 1 week also they are still experiencing pain and they are not able to walk. So, he is going to another doctor, he is taking X-ray and he is finding out that there is a fracture in the knee. So, he will treat him for the fracture of the knee and the patient get pain settled, but still he is having lot of pain. So, what happens is that he goes to another doctor. So, that doctor he finds out that he is having knee injury, along with that there is some injury to the pelvis also. So, the both doctors, the initial doctor and the second doctor, both of them have missed out on the exact diagnosis. The first doctor missed everything, while the second doctor missed one thing. So, both were negligent. When the patient came to you, you have to do thorough examination. You have to administer perfect skill and care to the patient. But you did not do. Both the doctors failed to do that. So, when two or more doctors are found to be negligent, we call it as composite negligence. And what happens in such cases is that the court will decide who was more negligent, whether doctor 1 was more negligent or doctor 2 was more negligent, like that they will decide and they will make them share the fine amount. This is how this composite negligence happens. So, the main type of negligence that we have to know is civil negligence, criminal negligence, then you have the patient negligence, contributory negligence, then composite negligence. Now, we have to know what is the main difference between professional negligence and professional misconduct, that is your ethical negligence. So, this can also be asked, what is the difference between these two? Here this offence, it is something illegal and punishable by law, while ethical negligence, it is mostly morally or ethically wrong thing. So, this is what we main definition of offence comes under professional negligence and ethical negligence. And the duty, like there has to be duty present, there has to be damage present. If we say something as a professional negligence, both of these have to be present, but to call an ethical negligence, these two need not be present. It may or may not present, but still if you do something morally wrong, then it will be called as an ethical negligence. And punishment here, it is either fine or imprisonment depending upon the damage caused. But in case of ethical negligence, it is always warning. If failed, then there will be penal erasure. So these are the punishment that can be awarded for ethical negligence. And trial, this is usually done by the court. And here it is usually your medical counsel. So this is the main difference between professional negligence and ethical negligence. Clear? Now, we will see certain important concept in relation to negligence. So this is very, very important. Negligence, they will ask you which thing is what, like that they will ask. So first is your Bolam test. What do we mean by Bolam test? So Bolam test is a concept that is used in the court to assess whether someone is negligent or not. So what happened was that there was one case that was known as Bolam case. So in that case, one judgment was given, and based upon the judgment they created certain criteria, and nowadays they are using that Bolam criteria to find out whether someone is negligent or not. So what does this Bolam test say is that, so first thing, the doctor, they have to have at least ordinary and accepted level of skill and expertise. Like what is standard? They have to have that. What I am trying to say here is that, like, then surgery has to be performed. You take one MBBS graduate and you are taking one surgeon who has done MS. So you are taking both of them, and if they are doing a same surgery, the MBBS graduate, he will do in a certain manner, and the surgeon with his experience and expertise, he will do in a perfect manner. Now, when you compare these both, obviously the surgeon would have done a better job than the MBBS graduate. But now, just because the MBBS graduate did not do up to the level of surgeon, we cannot say that that MBBS graduate is negligent. But if that MBBS graduate did not follow the standard operating procedure, if he failed to do a standard skill, like if he did not perform the surgery using the standard skill, applying a standard knowledge, then only we can call him as a negligent. If he has done a job perfectly, but maybe he had given the stitches a bit ugly, then we cannot say that he was negligent. The surgeon, he would have done everything perfectly, he would have done the sutures very, very perfectly. But that does not mean that MBBS graduate did a bad job. He still did the job. It may not look perfect, but it is what is enough, what is accepted, what is the standard care. So if he is fulfilling that standard care, then he can be considered as not negligent. If he is going below that standard level, then we can call him as negligent. So this is the first thing. Then second thing is that he have to follow one reasonable medical body's advice. Like if we take some diseases, there will be lot of school of thoughts. Some will say like antibiotic has to be given for 5 days. Some will say antibiotic has to be given for 3 days. Both are correct. He is right in his own way. So 5 days is also right, 3 days is also right. If you follow either 5 day or 3 day, it is fine. You don't have to follow, you have to follow this 5-day regimen very, very like mandatory, not like that. But this 3-day regimen, if it is not supported by any medical body, then you are not following rightly. So what the Bolam test says is that if at least one reasonable medical body advice is being followed, then it is fine. It need not to be the perfect body, but still it has to be something reasonable. Like in our country, we have ICMR and there is WHO internationally. So whatever ICMR, they will issue one guideline for treating the COVID. WHO, it will issue one guideline for treating the COVID. Now, you being a doctor, you can follow either ICMR or you can follow WHO guideline. So, if you follow either of them, then it is fine, no issue. But if you don't follow both of these and you create your own protocol and do treatment and the patient ends up dying or getting some severe damage, then you are at fault. So, some reasonable medical body, some reputable institutions criteria guidelines have to be followed by you, not your own guidelines unless it is certified by some proper institute. So, this is what Bolam test means. You have to have the standard skill and care, and you can follow one reasonable medical body's guidelines. So, if you follow these two, then you are not negligent. If you fail to follow these, then you will be called negligent. So, this Bolam test is what it is used to assess whether the doctor was negligent or not in the court. So, this is the first concept. Next, what we have is vicarious liability. So, vicarious liability means let the master answer. So, this is something very famous. So, vicarious liability literally means let the master answer. So, what happens is that you are a surgeon and your usual nurse, they are not coming for the surgery. So, you are getting another nurse from some other hospital. So, what happens is that that nurse does something irresponsibly. They did something negligent, that they left some swab inside the abdomen and the patient gets septicemia and dies eventually because of this negligence. Now, that nurse, since she was under your direct supervision, even if she had done something negligent, she is not responsible for that. Only the surgeon is responsible for that. Meaning, only the supervising authority, in this case, which is the surgeon, he is responsible for the mistake done by the nurse, because that nurse is acting under your instruction only. You should have checked yourself whether swab has been left or not. So, that thing was not done by you. So, this case we call it as vicarious liability. Even if your servant is doing some mistake, the master is responsible for that mistake and they will be called negligent. So, this is the vicarious liability. And borrowed servant doctrine means here if the servant is your own servant or borrowed servant, that does not matter. Whether it is your own nurse or nurse only appeared for that single surgery, it does not matter. As long as they are under your direct exclusive supervision, if they do some negligent act, you are responsible, not the servant who is responsible. So, this is the borrowed servant doctrine and vicarious liability. It is always the master who is responsible for the wrongdoings of the servant. The most common example we can give is under the chief or HOD, if an intern is performing a surgery, any negligence, any injury caused by the act of the intern, it has to be the responsibility of the surgeon or the chief who is supervising that intern. So, this is the common example that is given for this vicarious liability. Next we have is res ipsa loquitur, which is very important. It means the thing or fact speaks for itself. It is also known as doctrine of common knowledge. So, here what happens is that, like usually in case of negligence, how it happens is that when someone complains of negligence, usually the court will get an expert opinion. They will take opinion of some reputed doctor, only then they will conclude whether the doctor has done some negligence or not. This is how it is usually done. But in this res ipsa loquitur, there is no need for that expert opinion. Even a layman can say that some negligence has been done. Example is like leaving a cotton swab inside the abdomen, leaving an instrument inside the abdomen, So you don't need a surgeon or some expert to say that like negligence has happened. Even a normal lay person, someone who's even uneducated can say that that was the wrongdoing of the doctor. So those kind of thing or the fact that speaks for itself without any need for except evidence, we call it as res ipsa loquitur, and this is most important variant of negligence. And as the doctor, what are the negligence that we can claim against as a defense against the negligence? So first, medical misadventure or mal-occurrence. So medical misadventure or mal-occurrence is an unfortunate event. Unfortunate adverse event that happens even after following standard skill and care. So what I mean here is that, let's say how you administer antibiotic. Usually you will give test dose, and even if after test dose no reaction is coming, you will administer the bolus, right? This is how it is usually done, and this is the standard practice. You are doing everything properly. You are applying the test dose and nothing comes up, so you are applying the bolus. But after applying the bolus, suddenly the patient go into anaphylaxis. So this is something not commonly expected. This is something very rare and very unfortunate. So medical field, these kind of rare incidents can happen with anybody. You cannot predict it. Like the percentage, the probability that a negative test will give a positive anaphylactic reaction later on is very less. So these kind of improbable, unfortunate adverse event, we can always say it is a misadventure or a mal-occurrence. But here the only thing that you have to prove is you followed everything properly. You gave due care and you administered everything with proper standard skill. That thing you have to prove. So this is one defense. Next is novus actus interveniens. Here what happens is that a new act will break chain of events. So we will see this with an example. So one patient, he is your regular patient, he is calling you at night. At midnight he is calling you. He is a known CAD patient and he is saying that I have a chest pain, mild discomfort over my chest, and I am afraid it may be a myocardial infarction. Like that he is calling you in the midnight. You in your sleep, you don't listen to him properly, you just tell him it may be acidity, just leave it. Like that you are telling him. But after a few hours he is getting very severe pain and he is collapsing. So his wife is calling after that and she is saying that my husband has collapsed, I think he is having an heart attack. Like that she is telling you. So you realize your mistake and you are asking them to come to the hospital in ambulance. So actually you were negligent. So if the patient dies, it is your mistake. You should have properly listened to him and you should have properly treated him. But you did not do it. You are negligent, and if the patient died, you will be held responsible. But now what happens is that on the way to the hospital, when they are coming in the ambulance, an accident happens to the ambulance and they die because of that accident. So now the doctor was negligent. Doctor was negligent. And the patient dies. There is some damage to the patient dies. But this death is not directly due to this negligence. This is directly due to the accident. So this accident is a new event which is breaking this chain. So normally this negligent directly should have caused the damage to the patient. But here this negligent, it is bypassed by this new event, that is accident. So this novus actus interveniens, new act intervening and breaking the chain of events, we call it as a defense. So this is an act of serendipity. This is a coincidence, serendipity. It's like if you are very fortunate, you may be blessed by the God and something like this may happen. So this is also an defense. Next up what we have is res judicata. So what happens with judicata is that once decided in court, you can only appeal to a higher court, not contest the same in another court. For example, if someone is putting a negligence suit against you, it is a civil negligence and they are putting in a state forum and they are winning against you and you are giving them the fine amount. So, it is decided in a court. Now, if they want to do the case, if they want to appeal the case, they can only go to the national forum, like I want more amount, I want more fine, like that they can appeal to the national forum. But they cannot go and put the same case in another criminal or civil court and ask for punishment again. So, this once decided in the court, it can only be appealed, not contested again in some other court. This is also a defense against this negligence. Then we have this res indicata. This may sound similar, but it is completely different. So, res indicata means within 2 years of occurrence of said negligence, occurrence of that negligent act, the patient has to come and put the complaint. Like you cannot say like the doctor gave me injection wrongly in my arm like some 10 years back and now I am getting a swelling over the arm because of that injection, faulty injection I had this, like that you cannot come and say. Any damage, it has to be done within 2 years. Only within 2 years if a case is filed, then it can be taken as the negligent case. So, this 2 years is very important. If it is a slow growing condition, then it is different. But just saying that because of the faulty injection, now I am having edema over the arm, something like that, it cannot be quoted. So, this 2 years will apply in that scenario. So, this is one defense. Next, what we have is this contributory negligence. So, contributory negligence here, both patient and doctor are negligent. Both of them are negligent and this can be used as a defense only in a civil setting. In case of criminal negligence, we cannot use this contributory negligence as a defense. Only in civil, we can use this negligence. And what we have this doctrine of calculated risk. So, here what we'll do is like you have some cancer and radiotherapy is the only option left. But because of radiotherapy, there will be burns, there will be loss of hair, there will be lot of ill effects that will happen because of that radiation therapy. Now, if you are giving this radiation to somebody and if they are experiencing all those adverse effects, they cannot come and complain to the court that the doctor is negligent and I am experiencing all these burns because of this therapy. Because you are taking a calculated risk, you are weighing the good, greater good, right? So, the greater good is that only the radiation can save the patient. So, in the process of saving the patient, losing a hair or a teeth is not a big deal, right? You are taking a calculated risk. So, you can always use this as a defense that I have already told him that all this is possible, but getting radiotherapy done is more important than losing all these hair and getting burns. Like that, you can claim a defense. So, this is one another concept. And next defense that we can use is no duty owed. If he is not your patient itself, then there is no need for negligence suit. And patient negligence, obviously, if only the patient is negligent, then you can always use it as a defense. So, next thing is the product liability. Here what happens is that because of the faulty instrument, there will be damage. Here what you have to prove is you applied standard care and skill. Even after applying standard care and skill, because of faulty instrument, if someone is suffering a damage, then we call it as product liability. For example, you are applying an injection and you are following the SOPs. You are properly applying after taking all due precautions. But while applying the injection, the needle breaks and causes damage to the patient. And that needle has broken because of the faulty needle. The needle's quality is not good. So, in that case, the damage is caused to the patient because of that instrument. In such cases, only that manufacturer is responsible, not you who is responsible. So, it is the manufacturer's responsibility to face the negligence suit All you have to prove is you done everything with proper care and skill. So this is the product liability. So all these are the defenses that can be used by you as a defense against a negligence case. And this is very, very important. Each and every concept, it can be asked in the exam as a 2-mark questions. So this is the negligence part. Next, what we are going to see is professional secrecy. What is professional secrecy? So professional secrecy means like it is the secret of patient's history, his medical history. It will be held secret by the doctor. Like the patient's details cannot be shared to anyone else without the patient consent. For each and every patient, you have to follow this professional secrecy. Only if they give consent, you can tell the history to the other people, even if it is a spouse, even if it is a parent. If the person is a major, if they are more than 18 years of age, and if they tell you not to disclose your secret to anybody, even if the parents come and ask you, you cannot tell them. If you are treating them for free, even then you cannot tell the secret about their medical history to anyone. If a spouse is coming and asking about their secret, even then you cannot say. If you are publishing a case report regarding that patient in a journal, you cannot disclose the information without the patient consent. So patient consent is very, very important. You have to get the consent before disclosing anything about the patient to anybody. This is professional secrecy. But there are certain exceptions to this professional secrecy. That is your privileged communication. So when there is an exception to professional secrecy, we call it as privileged communication. What happens is that you will willfully disclose the patient's information to others. So this can be done in case of like government servants. If the government is sending them for fitness, or the insurance company, it is asking for fitness, then you can tell the details about the patient to them. Or if it is in the interest of society, like you are seeing a colorblind person being a driver, that information can be disclosed. If you are seeing a person with venereal disease using a common pool, that information can be disclosed. So like that, in case of society's wellness, you can disclose the information. Or if it is a notifiable disease like COVID, you have to tell it to the authority who are all having COVID. Those kind of notifiable disease, we can disclose the information even without the consent. And if the court orders for the information, you have to tell the information. Or for your own interest, if someone is putting a negligence case against you, you can disclose the information of that patient in the court. So under all these circumstances, you can disclose the information of the patient to others even without the consent. So this is privileged communication. And next you have therapeutic privilege. So what this therapeutic privilege is that normally you have to tell everything to the patient. So we do the informed consent, right? So every information about their condition, treatment, pros, cons, everything should be informed to them. But under certain circumstances, you will not tell them about their condition. So you will withhold the information like their diagnosis from patient. So this is known as therapeutic privilege. So why we usually do this? It is usually in patient's interest. Generally it should not be done. They should be told about the condition completely, but in certain condition, like if a patient is having suicidal thoughts, if the patient will not take something easily, and if you are finding him having some grave diagnosis, under those circumstances, you can withhold the information from him and you can tell it to your relative, spouse or somebody. So this is therapeutic privilege. So these are the main concepts that we have to know in this medical ethics, starting from the consent, then the types of negligence, then you have the ethical negligence and defenses against negligence that you can use, then this professional secrecy, exception to that professional secrecy is this privileged communication, and finally therapeutic privilege. So with this we are concluding this legal procedure and medical ethics. Thank you for watching.